Good afternoon, and welcome to the Jefferson Library at the Robert H. Smith International Center for Jefferson Studies at Monticello. We're so glad those of you that could join us in person today. This is the first in-person talk we've been able to do in about a year and a half. And of course, we welcome all of those who are with us on the internet. By way of technical procedures, before I get going, please make sure that your cell phones have been silenced. And after Paul is done doing his presentation, if you have a question, because we will be live streaming this, we ask that you come up to the microphone to have your question, and I'll try to be moderating the questions. But now it's my great pleasure to introduce Paul Finkelman. Paul Finkelman is currently the chancellor at Gratz College in Philadelphia. He received his PhD from the University of Chicago. He's taught all over the United States at various law schools and universities, including the University of Pittsburgh, Albany Law School, Harvard, Penn, Duke, the list goes on, Virginia Tech, Brooklyn, SUNY Binghamton, and so forth. His extensive list of publications, again, I won't go through because we would be here the whole time, me going through Paul's very extensive publication list. I will mention in particular Slavery and the Founders, Race and Liberty in the Age of Jefferson, which is in its third edition. And those of you who are familiar with academic publishing know that that suggests how important this volume is. Now, Paul's work, which has covered a number of issues in the early republic and in legal history, but especially the issue of slavery, some might suggest that Paul's work can on occasion be controversial. But as I've told a number of people, you must deal with Paul Finkelman's work. He does his work very well. He does his homework. His arguments are clear and persuasive. You can disagree with Paul, but you have to address Paul's work. Today, he's going to be talking about this book, Supreme Injustice, Slavery in the Nation's Highest Court. Again, I would like to hear from him on this topic, so I will simply mention several reviewers. One refers to it as an act of historical recovery, which I think is a very interesting and a very complimentary explanation. Another refers to it as enlightening and argumentative. With that, I hope you join me in welcoming Paul Finkelman.
Thank you, John. I appreciate all of you who have come today. Yesterday was the beginning of, I guess, semi-hurricane season in Virginia. We had terrible rainstorms. I think many people who had planned to come did not make it, so I am delighted with those of you who did. I know that among others, people from the John Marshal House in Richmond are here, and I am delighted to be here. Much of what I'm going to be talking about today will be about Chief Justice Marshall. We are on the grounds of Monticello and Jefferson's home, and of course, Marshall was one of Jefferson's many cousins in Virginia. Everyone was related sooner or later to everyone else if they were important. And yesterday, driving down here, I had the opportunity to drive through Fauquier County, which is where John Marshall grew up. And so I got to see the countryside of Virginia where Marshall grew up and where he owned an enormous amount of land, and as I will point out later, owned an enormous number of slaves. What I found fascinating driving through the county was that I did not see the word Marshall anywhere on any of the highway signs. I don't know why that is. Maybe if I had been on a different road, maybe a back road, I would have seen a historical marker or something. Well, I would have imagined when I entered the county, it would have said, "Welcome to Fauquier County, the home of Chief Justice John Marshall." Often when I drive through rural America, I say, I go to small towns and it says, "Welcome to X town, the home of the Fighting Lions AAA high school runner-up 1983. So high school football in much of America is more important than John Marshall. I think that's too bad. Marshall is an important figure, and writing about Marshall is interesting. Let me say how I got here and how I got to this topic. As a historian, I approach issues by trying to read as many sources as I can read. Earlier in my career, I was asked to give a lecture on Thomas Jefferson and slavery. And I started to prepare for that lecture, not by reading the books on Jefferson, because I already read many of them, but by going through all of Jefferson's available papers, all of his writings. And quite frankly, in the process of doing this, my thinking on Jefferson changed dramatically. I thought in the beginning he was simply a man of his times, caught up in an institution that he didn't like. I changed my mind. I talk about that in Slavery and the Founders. I'm, I suppose, proud to say that before DNA and evidence was available, I asserted quite boldly that Jefferson was certainly the father of Sally Hemings's children. All of the evidence pointed to that, and people denounced me for it until a couple of years later, they said, oh my, I guess he was. This is how we better understand our world. When I was writing the book that I'm talking about today, I spoke to a distinguished John Marshal scholar, and I talked to him about what I was doing. And in the process of one email conversation, he said, what are you trying to do? Just destroy the reputation of a great man? And my response was, no, I'm trying to understand a great man. So let me be clear from the beginning. Marshall was clearly an enormously important figure in American constitutional history and American political history. And I will say something about that in a minute. But it turns out that there's another story of John Marshall that is not particularly flattering, that is not particularly pretty, and it is a story that Americans have to come to terms with. This book began as a series of lectures I gave at Harvard University in 2009, the Nathan I. Huggins lectures, which are named for the first professor of African American studies at Harvard, and they're given as part of the Du Bois Center. I was asked to give the lectures. It's 3 lectures, and I thought, well, as a constitutional historian, I can give a lecture on the 3 great justices of the Supreme Court in the 19th century before the Civil War: Chief Justice John Marshall, Justice Joseph Story from Massachusetts, and Chief Justice Roger B. Taney. When we put those 3, the careers of those 3 men together, we have essentially the history of 19th century constitutional law up until the middle of the Civil War. It was easy to write about Story. Story was a New Englander who began as an opponent of slavery. He writes in a circuit court opinion. In those days, justices of the court went out and actually heard cases in trials. He wrote in a circuit court opinion that slavery was an obscenity. He went on and on and on, page after page, denouncing slavery, and then saying, we can't do anything about it. I don't have the power to do anything about it in the United States. But in this case, which was a slave trade case, I have the power and I'm going to act. And he said that slavery violated natural law. It violated every principle of law, and we should never support it in any way. He then moves away from that position in the next 20 years. And in his last major opinion on slavery in 1842, Story writes an opinion that could easily have been written by any slave owner in the South, totally upholding the Fugitive Slave Law of 1793, denying that slaves or alleged slaves have any due process rights when seized, and even going so far as to say that a slave owner who finds his runaway slave in the North is free to seize that person and take that person back to the South without any judicial proceeding whatsoever, which of course, as African Americans in the North immediately understood, was an invitation to kidnapping. Because if you can remove somebody without a judicial hearing, then you can remove anybody you want. And Story went on to say that no northern state could interfere with this process to protect the freeborn citizens of their own states from kidnapping or to protect people from mistaken identity. I knew a lot about Story. I'd written about him. It was easy. Taney was easier. Taney's the author of Dred Scott. And as they used to say on Monty Python, say no more, because we don't need to say anymore. But what's fascinating about Taney is that what he says in Dred Scott, which again I point out in the book, what he says that blacks have no right to be citizens in the United States is not something invented by an old man in the 1850s, as one defender of Taney, who taught political science at a nearby university connected to Thomas Jefferson, had put it as recently as around 2012, but rather what he said in Dred Scott on black citizenship is exactly what he said as the Attorney General of the United States for Andrew Jackson 25 years earlier in an opinion to President Jackson. Taney had consistently said blacks cannot be citizens. And of course, in Dred Scott, he faces dissents by Justices Curtis and McLean, who point out that blacks voted in at least 6 states at the ratification of the Constitution, including North Carolina, if they were free and not slaves, and that free blacks voted for delegates to the ratification conventions in 6 states. Free blacks voted for members of Congress. Free blacks voted for presidential electors. And so we have this weird view of Chief Justice Taney that you don't even have to be a citizen in the United States to vote for the president, to vote for a member of Congress, to vote for ratification of the Constitution. That's because Taney simply wanted to write black people out of the Constitution, out of our political process. I'm not going to go into these two anymore, but if any of you want to ask questions, I'm happy to take them. Marshall was harder because I read the biographies of Marshall. I'd read them long before. And virtually every Marshall scholar said the same thing. They said that he was not an active slave owner. They would say things like he owned a dozen house servants. They call them house servants rather than slaves, or enslaved people, as we might call them today. He owned a dozen house servants in Richmond. Now, actually, owning a dozen slaves in Richmond made you a multimillionaire by today's standards. It's an enormous number of people for household help for what is a relatively small urban house. It is not this great mansion up the road here at Monticello. That's a lot of slaves. And where did they get the dozen? Well, they read the first version of John Marshall's will. And in the first version of John Marshall's will, he says, I leave these slaves to my wife. And he names them. He actually names 15. And he also names and he also says, and the unnamed, doesn't name them, but he says, and the children of one of his other slaves. So it's probably 18 that he owns, not 12. Now, 12, 18, this is not a dramatically big difference unless you're the other 6 people, then it's a big difference. Or if we're trying to gauge just how enormously rich John Marshall was. And unlike his cousin Tom, John Marshall didn't spend more than he made or more than he had. And so he died a very wealthy man. So they all said he owned a dozen slaves in Richmond, and that he heard very few cases on slavery. And so there's very little discussion. There's a set of books called the Oliver Wendell Holmes Devised History of the Supreme Court that is named that because Holmes, when he died, left his estate to the United States government. And eventually the United States government took the money and created a scholarly committee to write the monumental full-blown history of each court based on the Chief Justice. These books are this thick. They're doorstops. Nobody would read them for bedtime reading. You wouldn't have enough nights to read them for bedtime reading, but they are fabulous resources, and scholars use them all the time. The first volume of the every Chief Justice gets 1 volume except Marshall, who got 2 volumes. And in the first Marshall volume, the authors, distinguished law professors and legal historians, do not mention the word slavery in the entire book, covering Marshall from 1801 to 1815. They do not mention a single one of his slave trade cases. They do not mention any of the cases involving black freedom. And nor do they ever take note of Marshall's personal slave owning. I find that shocking. I find it weird. There is one freedom case where they talk about the case because there's a scathing dissent by Justice Gabriel Duval, who had been the Chief Justice of Maryland and was a large slave owner himself, attacking Marshall because Marshall will not allow a black woman to argue that she's actually free. Duval eviscerates Marshall for this. The authors of the book write about the Duval dissent, but never say what the case is about. Because I guess slavery is not something that they are comfortable talking about. The second volume is even weirder. The second volume, written by, I don't mean to pick on Mr. Jefferson's University, but written by G. Edward White at the University of Virginia Law School, talks about slavery, talks about a few of Marshall's slave cases, and talks about the slave ownership of every justice on the court. And then White says, shockingly, John Marshall was not a slave owner. Duh. Huh? What are you talking about? How one, could a distinguished law professor say that? And two, how could a distinguished press and editors not catch this and say, what are you talking about? But that seems to be the take on John Marshall. In a later book, and by the way, Ed White is a friend of mine, or at least he was. Haven't seen him since this book came out. I like Ted White. He's a good scholar. He wrote a wonderful book called The American Judicial Tradition. I read it, I use it. In that book, he writes about Marshall. He says, Marshall had a strong and consistent commitment to the general inalienability of natural rights. I'll get back to natural rights in a minute, because when it comes to slavery, there's a very different story. And that's part of the story that has to be told. So, come upon Marshall, as I did, thinking, what am I going to say about Marshall and slaveholding? And in fact, when I gave my 3 lectures, the number of the people in the audience were kind of critical of the first lecture. They said, you really didn't say anything. And that's because I really didn't have anything to say. So I gave these lectures in 2009. The Harvard University Press said, okay, send us the manuscript when it's done, maybe 2011, 2012, 2013, 2014. Finally, my editor says, are you ever going to send me the book? And I'd never taken this long to write a book before. And I responded, I have nothing to say about John Marshall. I don't know what I can write. And then I was rereading a book about Marshall, written by a very good scholar named Kent Neumeyer, who taught at the University of Connecticut, on John Marshall and the Supreme Court. And Neumeyer does not talk about slavery a lot, but he talks about it more than any of these other scholars I have mentioned. And in the book, Neumeyer mentioned the fact that John Marshall added a codicil to his will. Marshall, by the way, wrote his will 3 times, which is really nice. Because if you're a scholar and you got 3 different wills, you can see a person's economic life change. You can see the interest that he has in things change. You can see how he's getting along with his children. In one version of the will, he disinherits one of his sons because he's got an alcohol problem and a gambling problem, and he's dissolute. The son had actually been at Harvard College and was kicked out for dissolute and immoral behavior. In Cambridge in those days, that could have been most anything. But nevertheless, so Marshall writes his son out of the will. Later, he puts his son back in the will, and later his son dies, and so he doesn't have to worry about it. But in the 3rd version of his will, after he'd written it, he adds a codicil, which is essentially an addendum to the will, in which he said that it is my wish that my faithful slave, my faithful servant, actually, is how he puts it, my faithful servant, Robin, should be free if he wishes. And I thought about this for a minute and said, I need to look at the will. I hadn't done that yet. I don't know why. It just hadn't occurred to me. But I'm only writing a little slice of John Marshall. I'm not writing a full-blown biography. So I look at the will, And the codicil says that it's my wish that my faithful servant Robin be free if he wishes. And if he will go to another state where he can be free, I'll give him $50. If he will go to Liberia, I will give him $100. At this time, it is not legal to emancipate your slave in Virginia unless you get the approval of the county court. Then you can do it. If John Marshal had really wanted to free his slave Robin, his faithful servant, he, the Chief Justice of the United States, one of the greatest lawyers in the history of Virginia, could certainly have gone into court ahead of his death and said, I want to make sure that Robin can be free when I die. I want to do all the paperwork now. I want the court to approve his freedom, and when I die, he becomes free. Or he could have put in his will, because he's a very wealthy man, I direct my executors to hire attorneys to make sure that Robin gets his freedom. Doesn't do any of that, because he doesn't really believe in black freedom. He doesn't really like the idea of a black man being free in Richmond. And so Robin never gets his freedom. And after reading that codicil, I read the whole will. So remember, so far what I know is John Marshal owns a dozen or 18 house servants in Richmond. Paragraph 3 of the will. I give to my nephew, Thomas Ambler, my tract of land on Chickahominy, which is today suburban Richmond. And I give to him all of the slaves, the farm equipment, the animals, the buildings. He calls it a plantation. All of us who have studied Southern history know a plantation is a farm operation with at least 20 slaves. No self-respecting Southern gentleman, and John Marshal is certainly a self-respecting Southern gentleman, would claim to have a plantation if he had fewer than 20 slaves. If John Marshal had 19 slaves, he would say, well, I own some slaves at Chickahominy on my farm. He wouldn't call it a plantation. Then in the next clause, it says, I give to my son Edward, who lives out on Marshall's land in Fauquier County. I give to my son Edward the land he lives on with the farm equipment, animals, buildings, and usual number of slaves. The next paragraph. I was going to give to my son John the land, the farm equipment, the animals, and the usual number of slaves, but because he's embarrassed me, I won't do that. And instead, he initially sets up a trust so that all of this can be used to support his son John Jr.'s wife and children. He wants to take care of his family. So I'm thinking, well, wait a minute. We got Chickahominy, we got 2 plots of land in Fauquier County. I contact somebody I know who's a crackerjack genealogist who's now doing a PhD at Morgan State University, a woman named Candace Gray. And I asked Candace if she can help me find the data. She's really good at this. And she gets back to me a couple of hours later and says, well, there's 64 slaves at Chickahominy. Now, I'm not a quantitative historian. I dropped high school physics when I discovered you had to know math to do physics. But I know that 64 is a lot bigger than a dozen in Richmond. And as they say on the late night advertisement, but wait, there's more. Because there's 20-odd slaves on Edward's land, and there's about 35 slaves on John's land. And she says, but there's also these other parcels of land out in Fauquier, want something called John Marshall's Quarters, and there's a bunch of slaves there, and there's another farm here. And pretty soon we're up to 150 or so slaves. And I know this is a lot more than a dozen in Richmond. And I write to a couple scholars. Because to be very honest, although I may be controversial, I don't know. I may even occasionally be arrogant. But I'm not comfortable writing something in which I say every person who's ever written about John Marshall is wrong, and people who should have known better didn't do their research, and some people who should have known better were misleading. I don't want to say that. I'm uncomfortable. So I send this information. I write up a couple of paragraphs on this. I send it to a couple of people. One guy writes back, my friend Kent Neumeyer writes back and says, "Wow, I wish I'd done the research you did." I later asked him why he didn't do it, and he said, "Well, it's really simple. I read all the biographies. I assumed they were right. And I was writing about him as a justice, and I wasn't that much interested in his personal life." Fair enough. You know, and Kent's work is terrific. The other person, who I won't name, who in those days was friendly to me, got back to me about an hour or two later in an email and said, "I was so interested in what you did that I went on Ancestry.com to see for myself." In other words, he didn't trust me. And he came back and he said, "You're wrong about 64 slaves at Chickahominy. There's only 61. You counted the overseer, his wife, and his child." Okay, so again, my mathematical skills are limited. You think there are a dozen. I think there are a dozen plus 64, and I'm the one who's wrong because it's only a dozen plus 61, excluding all the ones out in Fauquier County. So this is what I encountered. And that led me to do a deep dive into the papers of John Marshall and into the and into John Marshall's court decisions, because I figured if they're wrong about his slave owning, perhaps they're even wrong about his jurisprudence as a justice. And so when we look at what other people wrote, for example, Chuck Hobson, who was the editor of the Marshall papers for many years, and is an incredibly good scholar and a nice guy. Chuck wrote, Marshall heard relatively few freedom suits. Well, I took that as a word. Relatively, of course, is a relative term, right? In fact, the Marshall Court heard 14 cases involving African-American slaves who had a legitimate claim to being free. What could the claim be? Well, sometimes it's that their mother was actually free when they were born, and so they were free. They were freed in a will, and the will was never properly processed, and so they didn't get their freedom. Or in the case of Washington, D.C., they were brought into Washington by a migrant, and Washington, D.C. law. In those days, Washington, D.C. was two parts. Part was what is today D.C., which was governed by Maryland law. Today, Alexandria, Virginia. In those days, Virginia was Alexandria County of the District of Columbia, governed by Virginia law. But both Virginia and Maryland law said the same thing. If you migrated into the state, or in this case into Washington, D.C., you had to register your slaves within a very short period of time, pay a registration fee, because you couldn't bring new slaves into the states once you already lived there. Virginia is a net exporter of slaves, not an importer. Maryland is an exporter, not an importer. So there were a number of cases where people didn't register their slaves properly. So the question is 14 a lot, or is it relatively few? Given the narrow jurisdiction of the Supreme Court, given the cost, especially for a slave, of getting a case to the Supreme Court, I would think 14 is actually a fairly large number of freedom cases that the U.S. Supreme Court heard while Marshall was Chief Justice. I would later discover, because I would then read all these cases, any of which had been ignored by the 2 volumes of Marshall in the Oliver Wendell Holmes devised series. And what I discovered is that of these 14 cases, Marshall wrote the opinion in 7 of them, and in every one of these 7, the slaves lost. Justice Johnson from South Carolina wrote an opinion in another case, and the slave lost. But in the other 6 cases, which Marshall did not write the opinion, the slaves won. Now, in those days, very few people wrote dissents. Dissents are very rare. The reason there's a discussion of the Duval dissent in the freedom suit, which is known as Me McQueen, is because it was so rare for a justice to write a vigorous dissent. Sometimes they would just say, I dissent from this, but they wouldn't explain it, set it out. So Marshall, who dominates the Supreme Court, he writes more than half of all opinions on the Supreme Court while he's Chief Justice. By the way, this is before there are word processors, typewriters, or law clerks. He wrote 58% of all the court's opinions, 508 opinions. He wrote 25 concurrences, and he wrote 6 dissents. He rarely dissents. So when he loses in freedom suits, he simply shuts up and doesn't say anything because he doesn't want to write a dissent. He doesn't like dissents. So of the 14 cases, slaves win in 6 of them, and Marshall isn't around. They lose in 7 where Marshall writes the opinion, and they lose in 1 more. This tells us something about Marshall, and it says something about whether it's relatively few or relatively large. And I would argue that, in fact, 14 cases is relatively large. So who is young John Marshall? Grows up just a little bit north of here in Fauquier County. It's backwoods. Marshall wears what they called in those days a coonskin cap, a kind of Davy Crockett hat. He carries a hatchet in his belt because he walks around, and you sometimes gotta chop your way through the. The historians say he carries a tomahawk, which may have been what he carried, because you got to chop your way through the woods sometimes. He's about 19 when the revolution begins. He is an ensign in the local militia, which is kind of the lowest possible officer rank you can be. His father is the lieutenant colonel of the militia, and so young John's a low-ranking officer. His father eventually ends up being a full colonel at the end of the war. Marshall serves in the militia for a little while and then transfers out of the militia and goes to the Continental Line, serves under George Washington, fights up into New Jersey, serves in Pennsylvania, serves at Valley Forge, ends up as a captain. He has an interesting war career. He leaves the army in 1781 as the war is beginning to wind down. He studies law, goes to William and Mary for a very short time, then comes back, reads law, becomes a lawyer, moves to Richmond. He represents Fauquier County in the legislature. Then he remains in Richmond, becomes a lawyer there. He is a delegate to the Ratification Convention, argues vociferously in favor of the new Constitution. He's a state representative again. He is a diplomat. He is responsible for exposing the attempts of French officials to demand bribes to meet with Talleyrand during what becomes the XYZ affair. He comes back from France a hero and is immediately elected to Congress as a Federalist from Richmond. And from there, he becomes Secretary of State under John Adams. And when John Adams loses the election, Marshall is nominated to the Supreme Court. Just so you have some historical perspective on things, you may remember in the last year of Barack Obama's presidency, he nominated a person to the Supreme Court, and the Senate Majority Leader, Mitch McConnell, said that it's not appropriate to confirm a Supreme Court justice in the last year of a president's term in office. He forgot, of course, that the man that Obama was replacing, Justice Kennedy, had been confirmed in the last year of Ronald Reagan's term in office. But nevertheless, he says that. I wonder how Mitch McConnell would explain how John Marshall, who was nominated after John Adams has lost the election, and the lame duck president nominates him, and he's confirmed by the Senate. But he is. He goes to the court, and he serves from 1801 to 1835. Currently, that's still the longest number of years that anyone served as Chief Justice of the Supreme Court. And he becomes an important justice. He is remembered in many, many ways. There's a statue of him in front of the Supreme Court building. There's a statue of him inside the Supreme Court building. He has appeared on 4 U.S. postage stamps. He's appeared on a commemorative silver dollar. He's appeared on the $20 Treasury note in 1890 and 1891. These are things that Marshall House needs to collect and have on display. And he also appeared on the $500 Federal Reserve note in 1918. There used to be 4 law schools named for John Marshall. We're now down to 2. And most recently, just this year, John Marshall Law School in Chicago changed its name in part because of what I wrote in this book. Although that was certainly not my goal, and I was quite surprised that it led to that. But that's a whole different story. So, who is this young John Marshall? Well, he's a man who is on the make. He's a man who comes from what I would say is a prosperous but not super wealthy family in Fauquier County. His father, at the end of his life, or at the end of his life in Virginia, because he later moves to Kentucky, he owns about 25 slaves, a small plantation. He owns a fair amount of land in, again, very rural Western Virginia, not very well settled. Marshall moves to Richmond. He marries well. He understands that the best way to become rich in this country is either to choose rich parents, which he failed, or to marry somebody who chose rich parents, and he succeeds. He marries the daughter of the state treasurer of Virginia. That's a great match. And he immediately sets out to be a very, very successful lawyer, making lots and lots of money, getting very good fees. And he also becomes a collector of human beings. He begins to buy slaves on a regular basis. I don't want to read a lot, but let me just read a little bit so you can get a sense of this. In October 1783, Marshall pays 74 pounds. He's still using the Old English currency notation, 74 pounds for Moses. And he purchases shoes for a slave called Hannah, but we don't know when he acquired her. On July 4th, 1784, he pays 90 pounds for Ben. 3 days later, July 4th, the first anniversary of American liberty since the signing of the peace treaty with England, on July 4th, 1784, he buys 2 slaves, probably the children Eddie and Harry, for 30 pounds. He also pays 20 pounds more for 2 more slaves, which he refers to as servants. In September, he pays another 25 pounds for unnamed and uncounted servants. In November, he buys Kate and Esau. In 1784, he buys Harry, but forgets to record the price. So in a 12-month period, between 1783 and 1784, Marshall buys 9 named slaves, numerous unnamed slaves, and uncounted servants. And these are addition to what he already owns. This is a lot of slaves for an urban lawyer who has just gotten married and doesn't have any children. He's not even buying people, to help take care of the baby, because there aren't any yet. In 1786, he pays 50 pounds for 2 slaves. In 1787, he buys Israel for 55, and he pays 55 pounds for a woman bought in Gloucester. He later makes a down payment of 11 pounds for 2 more slaves, and he has to pay for the burial of the slave Sam. We don't know when he acquired him, but he complains that he didn't get his money's worth because slave Sam died on him before he could get his value out of owning Sam. In 1784, on July 4th, in 1787, on July 4th, while the Constitutional Convention is meeting in Philadelphia, Marshall celebrates Independence Day by buying slaves, this time a woman and her child, who he then passes on to his father-in-law, Jacqueline Ambler. That same day, he pays money for another slave. In August, he pays 50 pounds on slaves, and he buys an unnamed Negro man. Now, what's interesting about these records is sometimes he names the slaves, sometimes he doesn't. Sometimes he tells you how many he's got, and sometimes he doesn't. And this is a man who is seeing slaves as simply a way to accumulate wealth. These are widgets. It would be as though on July 1st, I called up my stockbroker and bought 50 pounds of stock, 50 shares of stock. Sometimes I'd say what I bought, sometimes I wouldn't. This is the accumulation of property to make a man wealthy. We know that by the mid-1780s, he's purchased just in the last few years at least 15 slaves, and he continues to buy them. We know that he gives, in the 1820s, almost 30 slaves to his son Edward. We know that he gives, that his son John is in possession of almost 40 slaves in 1830. We know that another one of his sons, Jacqueline, who is a doctor but doesn't seem to have much of a medical practice, and again lives on Marshall land out in Fauquier County, owns about 47 slaves in 1830. He owned none in 1820. 47 slaves would be the equivalent of, $10 million today, perhaps. I mean, it's a huge sum of money. A starting out doctor without much of a practice didn't buy those slaves. He probably got them from his father, maybe a few from his father-in-law as well. All of John Marshal's sons are large slave owners. In fact, when you begin to count all of the slaves owned by people named Marshall in 1830, just in Fauquier County, you get into the many hundreds. In none of these things does he mention the families of slaves. At one point, he says he bought a woman and her child. What about the woman's husband, if she had one? What about other children? What about the father of the child? He doesn't care because he is like other Virginians at the time. Now, I don't want to belabor this point. This was the system. This was the society. But when historians come along and talk about how he believes in the unalienable or inalienable natural rights, you have to wonder, what are they drinking? Or what are they smoking? What fantasy land do they live in? Clearly, he doesn't believe in the natural rights of slaves. By the way, his son, Thomas Marshall, in 1830 owns 64 slaves. It's a lot of slaves. So that's John Marshall, the slaveholder. Again, his biographers say he treated his slaves well. He was kind to his slaves. I don't know what their evidence is. My reading of John Marshall is that he is not a violent man. He's not a vicious man. He's not a brutal man. I don't think he whipped his slaves. There's one story where his servant Robin forgets to pack his pants when he's going off to hear cases, and he gets to the courthouse and he doesn't have any dress pants to put on, and he, chides Robin a little, but he doesn't get mad at him. He says, "I'm going to send you to the whipping post. I'm going to sell you." Nothing like that. I don't think John Marshall's a brutal man. He may very well have treated his slaves kindly, if you think being separated from your family and becoming John Marshall's slave is a kind thing. But do we know how his son John Jr., who is an alcoholic, treated his slaves? One can only guess. Sometimes when people drink too much, they get very quiet and peaceful. At other times, they get very violent. We simply don't know. And so the thing is, you can't make a statement as a historian and a scholar without some kind of evidence. And the only evidence we have is that there isn't any. And that's how you have to approach these things. While Marshall is accumulating slaves and hearing cases involving the African slave trade and slave freedom, he is also the president of the Richmond branch of the American Colonization Society, which is a society dedicated to moving free blacks to Africa. In 1831, in Southampton, Virginia, there is the most bloody slave revolt in American history, the Nat Turner Rebellion. And after the Turner Rebellion, Marshall goes to the Virginia legislature and he asks the Virginia legislature to appropriate a significant sum of money to remove all of the free blacks in Virginia. He says the entire nation, quote, could be strengthened by, quote, the removal of our colored population. He believes the danger from free blacks can scarcely be estimated. He goes on to say that half the free blacks in Richmond are criminals. He knows better. And certainly as a judge, he could have found some of the statistics. He just doesn't believe in black freedom. He says the urgent expedience of getting rid in some ways of the free colored population of the Union must be supported by the Virginia legislature. His biographers conveniently don't like to write about this printed statement, which is easily available, that he gives to the Virginia legislature. So I know that we're running low on time, and I want to, I know we got started a little late. So I want to briefly say something about the cases, and then I'd like to take questions if people have them. So in the freedom suits, there are a series of freedom suits which involve slaves who have legitimate claims to freedom. One example is a man named London. He's referred to in the court case as Negro London. Negro London, or London, sues for his freedom in the District of Columbia under the Virginia law that requires that you register a slave if you move into the state. He was not properly registered. A jury of 12 white men, probably some of them are slave owners, presided over by a slave-owning white judge, rules that London is free and should be set free. The trial court, among other things, discovers that London was sent to Alexandria before his master moved there, and well before the master said he was moving there permanently. Clearly violates the law. Marshall finds an excuse to overturn the decision. In another case, a man named John Davis proves that his mother had always been free. What is the proof? That the courts in Maryland had declared his mother had always been free. She'd never legally been a slave, and therefore all of her children were born free. Her children in Maryland immediately get free. John is in DC. He sues for his freedom. And the answer should have been really simple. District of Columbia recognizes the Maryland decision that your mother was always free, and therefore you are free. End of story. And that's what the jury rules. Marshall overturns the verdict, making a weird and legally strange argument that John Davis's owner had not been allowed to litigate in Maryland. He was not part of the Maryland case. And therefore, he should have been allowed to interpose on behalf of his ownership of the slave. But this has nothing to do with the case in Maryland. The Maryland court had plenty of evidence that the woman had never been a slave. Now, when the owner of John Davis bought the slave, he probably got a warranty of sale saying that John Davis is a slave for life under Maryland law and became a slave for life when his owner migrated to the District of Columbia. The current owner of John Davis had an easy answer. He should have sued the guy who sold him for selling him somebody who wasn't a slave. But rather than do that, Marshall simply says, sorry, you're not free. In another case, Marshall writes that the statute in question is ambiguous. And he says it could be determined one way or the other way. And when I read this, I thought, aha, Marshall's going to free a slave. He said we could decide the case one way or the other without doing any damage to the interpretation of the statute. And so he decides the person remains a slave. In every one of these cases, he finds a way to hold somebody in slavery. He hears a number of cases involving the African slave trade. And in every one of, and by the way, the African slave trade is illegal after 1808, and American participation in the trade is illegal after 1794. So he finds people who have been illegally involved in the African slave trade, and he always finds a way to let them off. In one case, there is a boat that leaves either the port of New York or the port of Perth Amboy, which is in New Jersey, goes out into the Atlantic Ocean, picks up a bunch of illegally imported slaves in the middle of the ocean, and brings them to Louisiana and tries to sell them in New Orleans. Marshal rules that the conviction is to be overturned because the prosecuting attorney said that he left either New York or Perth Amboy, and the prosecuting attorney doesn't know where he left, and therefore we have to throw the case out. Never mind that the boat arrives in New Orleans with obviously freshly imported African slaves in clear violation of the law. Any judge, particularly a judge as smart as John Marshal, could have figured out how to uphold this conviction. He doesn't. Final slave case I want to mention is the case called the Antelope, because the Antelope is the big John Marshal African slave trade case. And in the Antelope, John Marshal says things that make his biographers happy because he says that slavery is a bad. He even says that slavery violates natural law. But then he goes on to say that natural law has no place in American constitutional law, and you cannot apply natural law to American constitutional law. This is, in fact, a direct slap in the face of his closest colleague on the court, Joseph Story, who had said it in the case I mentioned way back in the beginning of this talk, Junet, where Story said slavery violates natural law. So here's what's interesting. When I taught con law in law schools for 20 years, I would teach Fletcher versus Peck and Dartmouth College versus Woodward and Ogden versus Sanders. And in all of these, Marshall makes natural law arguments. In Ogden versus Sanders, Marshall writes one of his 6 dissents. He is dissenting from a case upholding New York's bankruptcy law. He hates bankruptcy laws because people who owe you money don't have to pay you if they are allowed to be bankrupt. And Marshall has a significant amount of money that is being lent out. And so he doesn't like debtors. He likes people who hold debt like himself. And so he dissents in this case, and he says that a bankruptcy law is a violation of natural law, and therefore it should be struck down. So when it comes to slavery, natural law doesn't apply, but when it comes to money, it does. That's part of the legacy of Chief Justice John Marshall. I could go on, but I've talked long enough, and you've all been very patient. So let me take questions.
Thank you. I think go to this microphone to the left. I think you can understand why this has been referred to as an act of historical recovery, and a very important act of historical recovery. As Paul was good to point out when he started, it's not a question of liking great men or not, but we have to start with an accurate understanding of the history if we hope to understand our own history as well as these great men. I have a number of questions I could ask, and as the chair I could do that, but we got started a little bit late, and I know we're going to run a little bit late, but let me start by asking if anyone has questions, and we'll defer to the audience. If not, Paul, let me ask something.
There's a question in the back.
Yes, please.
I am the proxy for those who are watching online. So let me give you 2 questions from our viewers. Natalia, a super fan from Madrid, wants to know why so many people were trying to hide the facts.
I'll answer in English because my Spanish is not good enough. She's from Madrid? That's wonderful. I love having an international audience. I think it's 2 things. One is that, unfortunately, many biographers fall in love with the person they write about. They become the alter ego of the person they write about. And so when they encounter something that doesn't fit with their world, they don't want to talk about it. That's the first thing. The second thing is that many of the biographers of Marshall are interested in Justice Marshall, the lawyer Marshall, And slavery does not fit into their worldview. It does not fit into the constitutional world that they want to talk about. Look, it's a very uncomfortable subject. It's very hard for Americans to come to terms with this. I had a wonderful tour of Monticello today. My tour guide was terrific, talked about Jefferson's slave owning, talked about fathering children with Sally Hemings, as well as before that with his wife, Martha Wales Jefferson. I reflected back on the first time I came to Monticello, which was longer ago than I want to admit. It was 40 years ago. And I asked the tour guide where the slave quarters were in relation to the house. And the tour guide yelled at me and said I was trying to ruin the reputation of a great man with spurious lies about his character. And I said, no, actually, I'm a historian, and I'm just kind of curious as to where the housing was. But Monticello, in other words, has come to terms with the reality of Thomas Jefferson. It is no longer St. Thomas of Monticello. It is now a great man who contributed greatly to the history of the United States, who was far from perfect. And that's taken this institution at least 3 decades to get to. I think biographers just don't want to do it. I will give you one example. I asked one Marshall scholar how many slaves he thought Marshall owned. And I expected him to say a dozen in Richmond. And he kind of cocked his head and thought for a minute and said, must have had 150 at least. And I said, why didn't you say that in the 2 books you wrote about Marshall? And he said, because it's not important.
Okay, question number 2 from our online viewers. Did Marshall's land holdings change during the time as usually slave purchases followed acquisition and clearing of land for many increases in tobacco cultivation? So is there a connection between land acquisition and slave acquisition?
So when Marshall's not buying slaves, he's buying land. And of course, he creates a consortium with his brother and a couple of other people to buy the land that was once owned by Lord Fairfax, as in Fairfax County, Virginia, approximately 200,000 acres of land, basically Interstate 66 going out of DC. After you get about 20 miles outside of DC, you're driving through land, much of which was owned by John Marshall, as well as land that he acquires in Fauquier County. Marshall is a huge landowner, and as a huge landowner, he sells land, he buys land, he's very interested in land. I think that his acquisitions of slaves are in parallel with acquisitions of land, but that Marshall figures out very early in life that there are only 2 ways to get rich in Virginia: land and slaves, and if you can do both, you can get very rich. And he's interested in that. It, by the way, is significant that, unlike his cousin Thomas, he doesn't inherit large numbers of slaves. He's buying them. He's out there in the marketplace buying human flesh. And he's buying land at the same time.
Let me, Paul, first of all, Paul's comment about biography. Having written a biography.
Take your mask off so people can hear you.
Thank you. Having written a biography, Paul's comment about biography is certainly true. One has to, it's difficult to write a biography and try to maintain a distance from the subject who you spend years sort of living with mentally. But if we don't have additional questions, I'll ask a broad, but I think an important question, and maybe we can wrap up with that, because you mentioned things several times that jump out at me. Those of you that know me, I'm formerly a lawyer and was a litigator. And you mentioned about the Holmes history of the Supreme Court, and you said in the first volume, maybe they just didn't want to talk about it. And then talking about Neumeyer's book, he said, well, I'm interested in John Marshall, the justice, not his personal life. And yet, as a lawyer, I would certainly be, and if I were bringing a freedom suit or a case involving the slave trade, or for that matter, a case involving any contract case involving private property, I would certainly be interested to know that the justice sitting in the case was a major owner of enslaved people. Could you just expand a little bit on this idea that people don't want to talk about it, and that even lawyers seem to think it's not relevant to the case?
The short answer is yes. I mean, look, it's a problem. I would say that judges are not created in the clouds somewhere. They don't come down from Mount Olympus without a history and without personal interests and without things that are important to them. They come to their position usually fairly late in life. I mean, Marshall is pretty young for a Chief Justice. Usually they come with a long career, which is why when we look at, say, Supreme Court justices, the confirmation hearings are so contentious. If we look at some of the hearings over Brett Kavanaugh, for example, or Clarence Thomas, should we care about their personal behavior towards women? And the answer is, well, if they're going to hear cases involving women's rights to control their own body, for example, I would think we would care what their personal behavior has been in their life. It is not the only determinant. And it's certainly true that people change over time. During his very early political career, Hugo Black was a member of the Ku Klux Klan. When the Brown decision is first before the Supreme Court, Black is one of two justices on the Supreme Court who says, we must finally just say segregation's unconstitutional. And he says, yes, there will be a reaction. There may even be violence. I'm from Alabama, I know. And that's what we have to do. So people change, but certainly a political figure, and Supreme Court justices are political figures whether they want to be or not. The private interests of a political figure may affect how they determine their policy. In terms of the scholars, I think it comes back to the fact that people are simply very, very uncomfortable with dealing with slavery. Slavery is not something people want to talk about. They're not something people want to acknowledge. They don't like the idea that we had slavery in the United States. And so they're just uncomfortable, dealing with it in any kind of meaningful way. Kent Neumeyer, I was hoping I could pull out Kent Neumeyer wrote, Marshall's slavery jurisprudence is painful to observe, but asserted Marshall adhered to the law of slavery only because his system of federalism deferred to the states on questions of slavery. The only problem with that is that Marshall doesn't hear any state cases. He's only hear cases in District of Columbia. And what he's being asked to do, in fact, is to enforce Maryland and Virginia law. Virginia could hardly have complained if Marshall had freed a few slaves because Virginia law said they would be free. Maryland could not have complained if he had freed John Davis because Maryland had already freed the rest of his family. People don't want to face the fact that that's who he was and that's the world he lived in. And I just think that in our world today, we have to face this. We have to come to terms with it.
We have one more question. Maybe we have one more question, and then.
I'm aware of present-day marshals who have a history in Culpeper County, next to Fauquier, that they are descended from John Marshal. And I'm wondering what you know about either a genetic connection, of course it could be through one of his sons, or black people who came from that general area who, genetic or not, use the name Marshall. Do you know about any of those kinds of connections?
African American.
These are African Americans.
Yes.
Yeah, you said people, I wasn't sure.
Oh, yes.
In this context, we have to be, specific in that way. Look, Marshall is not an uncommon name. Okay, there are lots of Marshalls in the United States. As many of us know, many English last names are the result of jobs people have, right? People named Carpenter, people named Farmer, people named Joyner, people named Marshall, people named Priest. People got names based on what their families did. So I would guess that there are probably a significant number of people from England who moved to what became the United States, whose name was Marshall, because there are marshals and sheriffs all over England. So that's one piece of it. Two, we know that as slavery comes to an end, and as former enslaved people begin to stake out themselves as being free, many of them take the names of the families that held them in slavery. So there are lots of people who are named Marshall, perhaps because they were owned by part of the Marshall family. I know of no evidence, because I get asked this all the time. Did Marshall father children with his slaves like Thomas Jefferson did? I have no reason to believe that he did. For one thing, Marshall is incredibly happily married, as best we can tell. I mean, the letters back and forth between Marshall and his wife are truly tender. He really is in love with the woman he married. The two people from the Marshall house are shaking their heads. I don't think there's anything about John Marshall that would have inclined him to take up with a slave woman. I also don't see where he would have done that in the Marshall home. It's a pretty tight space. There's not a lot of evidence.
Well, as I say, it might have been
Right.
the sons, but at any rate, by your own lights, what you're saying is you don't know of any evidence to date. But this may well be a subject where the historical facts are yet to be uncovered.
Right. And the DNA evidence would be easy. Marshall has a bunch of kids, and I assume that there are people who are descendants of John Marshall. In fact, I know somebody who is both a descendant of John Marshall and a descendant of the first Chief Justice, John Jay. Their last name is Jay, but at one point the Jays married into the Marshalls, because after all, where else would children of a Federalist Supreme Court justice go to but the children of another Federalist Supreme Court justice? You marry people like yourself. So I imagine it would be possible to find enough DNA from from white Marshals who can surely show a descendant from John Marshall. And then go to, if you can just give me half a second, and then do comparisons with people from the African American community that bear the name, and then you might find out their relatives.
Well, if you're interested, as I say, I do know African American Marshalls who have that family history, not just bear the name. So, if you should yourself or anyone else be interested in following through, I might be able to be of assistance.
I'll be happy to give you my card. We can talk. But I will tell you this: the question you're answering, the question you're asking, I think goes to an essential element of American history. Americans are a people of Euro, Afro, Native, Asian, Pacific Island, Hispanic heritage. We are a mixture of people. We have different genetic backgrounds. We have family backgrounds. And certainly the number of slave owners who fathered children with their slaves, and the very small number of women slave owners or women from slave owning families who bore children whose fathers were slaves is huge combined. Mostly it's men, white men and slave women, but it's a huge number. And it is entirely likely that large, significant portions of the African American population have some European ancestry. How could they not? Because of racial barriers, things like marriage and laws defining race, it is less common that people who think of themselves as whites are likely to have African ancestry themselves, although they have plenty of cousins who do. But that's also probably a much bigger number than people realize today. I'll give you one quick Virginia story, if I may, and then I promise I'll shut up. In the 18th century, you were defined as white if you were more than 3/4 white. That is, if you had 3 white grandparents and 1 grandparent who was half white and half black, you were considered white. Okay? If you had 3 white grandparents and 1 black grandparent, you were not considered white. There's a very good chance, by the way, that under Virginia law, Sally Hemings was white. Okay. Later, so basically, if you are 1/8 black or less, you are white. Later, Virginia changes that to 1/16, which means you have to go further back. Then in the 20th century, and by the way, this has fascinating implications when they change the law for marriages, because white people and black people can't be married. So a white person could have married somebody who is 1/8 black, and that's a legal marriage. And now suddenly that person is no longer white. That person is black because the 1/16 has changed their designation. So they actually had to allow those marriages to continue. But it gets weird. And then Virginia goes to the fact that a white person is someone who has no drop. This is the 1 drop rule. No drop of any non-white ancestry, no drop of any non-white blood. Virginia does this in the 1920s. And immediately there's a crisis in Virginia, because some of you have probably heard of Pocahontas. Pocahontas married John Rolfe, the secretary of the Virginia Company. They had 2 children who lived into adulthood. Those children had children. And there are many people in Virginia, the first families of Virginia, who proudly trace their ancestry to John Rolfe and his Native American wife. And so these people were people who had at least 1 drop of non-white blood, and under the new law, they're no longer white. And immediately the legislature passes a law amends it by saying, except for people who, and I think it was, have either 1/16 or 1/32 of Indian blood, then they can still be white, because they had to protect their own racial identity. Enough?
Yeah,
you want one more
I mean,
question?
Paul, those of us who work in public history, especially early American public history, certainly understand what Paul is saying about this can be a difficult topic. It's a topic we have to engage. I find it curious and interesting, the legal tie-in here, and the fact that lawyers have equally been unwilling to engage us. This is an important book, Supreme Injustice. I should mention that there are going to be copies upstairs for sale, and I'm sure that Paul would be happy to sign them if you purchase one. But thank you for joining us. I'm not sure I introduced myself at the beginning. My name is John Ragosta. I'm a historian here at the International Center for Jefferson Studies, and I ask that you keep an eye on our website. We hope to be having more in-person book talks and fellows talks as the year goes on, and we certainly look forward to other scholars like Paul joining us and helping us in this educational process. So Paul, thank you so much.
Thank you, all of you.